I just wanted to very briefly talk about a case that came before me 2 weeks ago. The issue in that case is whether Parmesan is the English translation of the Italian term Parmigiano Reggiano. And my European colleagues will know that there are two decisions of the European Court of Justice on this issue, but they don't decide this issue that is before me, whether it's a translation. Yes. Yet there are two opinions by the Advocate General in two different cases. One says it's a translation. The other one says that there is no sufficient evidence for him to say that it's a translation. So I'm caught in between now. I have to decide the issue where there are two differing opinions of the Advocate General, but no guidance from the European Court of Justice. So although the laws are similar, we have in fact amended our Geographical Indications Act on account of the FTA with the EU, but yet you still have to decide these issues yourself because there is no guidance.
Excuse me, Parmigiano is a appellation d'origine, and it's protected in the European Union and also by the Lisbon Agreement on geographical indications. And it's very simple.
But not Parmesan.
Not Parmesan. That's the issue before me.
Exactly. The question is it a translation or not?
Yes.
Or is it a different word?
Yes. Yes, that's the issue before me. The Italian term, of course, I know it is recognized even in Singapore.
Mm-hmm. I must say we have a lot of these kind of cases. We have all the halloumi cases concerning some allergies and some other relation between trademarks and geographical indication of property, or a lot of cases coming from the industry making salami or other similar products, where really you have very new principles of how to cope at the one hand with trademarks, on the other hand with indication of geographical provenience, with the different types of procedures which are administratively possible to be used to protect this geographically clearly defined product. And I think it's very, very interesting. Sometimes even on the situation how to cope with the idea whether a trademark refers to a place which will be giving a certain strength to the product or the service can be very difficult. I would just cite the Neuschwanstein case where Elizabeth knows it very well. There is a difference in the German approach and the European Union level approach. That means that there are some souvenirs which are called Neuschwanstein are in fact taking something from the very well-known castle that exists or not. So I can imagine that also with the Parmesan question, it might be interesting to see the final decision of the Court of Justice after the Attorneys General.